Okay, we are back to discuss Planned Parenthood versus Casey. And this is a case following Roe versus Wade by a number of years. And the court spent the interim between those two cases trying to sort out of what the right to abortion consisted and how it would evaluate that right. I'll note that the tenor of the cases, of the issues presented in cases, shifted from is abortion legal to what sorts of regulations may states place on the right to abortion in an effort to assert its interest in life. And I noted that in Planned Parenthood v. Casey, the court adopted the undue burden test. Let's go back just for a moment and review the Roe trimester framework. So this is table 16-2 that I mentioned to you earlier, and this is sort of the balancing approach that the court took to the right to abortion under a right to privacy, balancing the interests of a woman in obtaining an abortion with the interests of the state in regulating that right and also maintaining life. So we see on the left-hand side there the stages of pregnancy, and we have from conception through the end of the first trimester, approximately 3 months, and then the next trimester, the end of the first trimester through viability, approximately months 4 through 6, and then subsequent to viability, approximately months 7 through 9. And then we have on the right-hand side there degrees of permissible state regulation of the decision to terminate the pregnancy. So we look at then the first trimester. The state's interest is at its lowest ebb. It has almost no justification for state regulation. The court said the abortion and its effectuation must be left to the woman and the medical judgment of the pregnant woman's attending physician. Then in the second trimester, we say that the state has some interest, and the state, in promoting the interests of the health care of the mother, may, if it chooses, regulate the abortion procedures in ways that are reasonably related to maternal health, but it may not prohibit abortions. And then in the final trimester, the state's interest in life is at its highest ebb, and the woman's interest in obtaining abortion is at its lowest. So look at what the court says there, the quotation that's been pulled out there. Really what that quotation defines is a rational basis review. The state, in promoting its interest in the potential of human life, may, if it chooses, regulate and even proscribe abortion, except where necessary in appropriate medical judgment for the preservation of the life or health of the mother. All right, this is the framework that the court sort of jettisons. It doesn't sort of jettison it, it does, in Planned Parenthood versus Casey. And the reason for this is because medical technology had improved to such a degree that the point of viability, let's go back and look here. So you'll see the end of the first trimester through viability, approximately months 4 through 6. It had moved back viability, which is defined as the capacity of a child to survive outside the womb. Viability had moved back in time significantly because of advances in medical technology and also in prenatal health care. So basically, Justice O'Connor says in Akron versus Planned Parenthood of Ohio, basically Justice O'Connor says viability is a moving target and that a rigid trimester framework simply will not work to help decide when the state's interest in life begins and when the mother's interest in obtaining of an abortion ends. It's just impossible to nail it down with a rigid trimester framework, and the court says we have to find something else. So it substitutes for this what's called the undue burden test. It substitutes for the Roe trimester framework, the undue burden test. It's important to note here that all that survives of the Roe decision is the holding that a right to abortion does exist. The court has never treated this right as fundamental. In fact, Sarah Weddington and Coffey, the attorneys for Roe, argued in court for an absolute right to abortion up to the day before birth, and the state of Texas argued for an absolute interest of the state in life from the moment of conception on, and the court never bought either one of those arguments. So Roe is one of those cases where both sides lost. The court didn't adopt either one of their logics. So in Planned Parenthood v. Casey, though, the court finds that the logic that it did use in Roe unworkable. Now, Pennsylvania had passed a number of regulations of the abortion right, and some of these involved just record keeping and other sort of mundane kind of things, but others of them involved informed consent. So in other words, the idea that the state could require that before obtaining an abortion, a woman read material and take consultation with a physician or watch a pre-prepared movie or something like that. It also involved spousal notification, so the requirement that a spouse be notified and agree before a woman could obtain an abortion, and also a requirement that for a minor, a girl who is pregnant, she obtain parental consent. Now these are the regulations that that Pennsylvania had placed on the abortion right, and the Planned Parenthood of chapter of southeastern Pennsylvania sued the governor of the state at the time, Casey, and the question before the court was, do these provisions, the spousal notification, record keeping, informed consent, and parental consent, do these provisions violate the constitutional right to privacy and the right to obtain abortion, which is part of the right to privacy? The court, the decision is mixed. Okay, it says here that the court announced the judgment in favor of Planned Parenthood of Southern Pennsylvania. Some of the provisions were upheld and others were struck down. And the court says, it is imperative to adhere to the essence of Roe's original decision, and we do so today. The court has said in Casey that there is a right to privacy, and that right contains a right to obtain an abortion. This is settled law. So that when a court says something like that, it means that there is no chance that it will reverse itself, none whatsoever. And so when you hear politicians say we need to overturn Roe versus Wade, what they're really doing is they're trying to activate their base. There is absolutely no chance, none whatsoever, that the Supreme Court will overturn its decision, finding that there is a right to an abortion and a right to privacy as part of the right to privacy. However, the regulations that the court will allow are pretty extreme, and it suggests that the court does not view the right to obtain an abortion as fundamental. And it does not in all instances, in fact in most instances, it does not apply a strict scrutiny test. The kind of test that the state has the hardest time justifying its policy under. The court doesn't apply it. So in Casey, the court upholds informed consent. It says, certainly the state's interest in life suggests that it, along with a woman and a doctor, would want to engage in a process of making a decision together, and that would involve some information, and consent on the part of a woman after reading that information. It struck down spousal notification because that was an undue burden on obtaining an abortion. There is no reason, according to the court, why a woman who has reached the age of majority under the law is required to obtain the permission of her spouse before obtaining an abortion, so they struck that down. The court upheld parental consent. However, that parental consent always comes with a caveat, and that is that where a minor cannot obtain parental consent because she fears for her life, or she fears that she will be thrown out of the house, or that violence will be conducted on her body by a parent, that or there are other forms of abuse in the house, then the court says that there must be a judicial bypass. So that concludes our discussion of Roe versus Wade and the Planned Parenthood versus Casey decision of 1992.